Manager Mike Noel, I'll turn the floor over to you, sir.
Thanks, Deputy Mayor. Yeah, I want to, I guess, fairly briefly cover what is, I guess, to most would be a pretty boring piece of legislation, but it does have impact on this community as far as building code enforcement, and to the point where I believe it was necessary to advise council and, more importantly, the public of changes that are coming on the enforcement of building-related matters. So what is the Building Code Administration Act? It's basically a provincial act that regulates the design, construction, alteration, replacement, and demolition of buildings. The important point to note there is that it's buildings. These rules do not apply to fences and other structures. And there are buildings that are exempted, for instance, construction trailers and temporary buildings. But this is how the enforcement of rules related to the construction of buildings will take place moving forward. It formally adopts the 2015 Building Code of Canada in New Brunswick. Up until recently, New Brunswick had adopted the 2010 Building Code. So the impact of that alone is obviously that people who are designing homes or looking to build homes, the rules have changed, and they are well advised to make sure that their rules comply with the building code. There are different levels of building plans you can pick up, some of which comply, some which don't. But that is a fundamental change, and we're encouraging the public to understand that the rules have changed. It also applies to the demolition of buildings, and more importantly, changes in use. And at City, we've run into some files recently where a building has been used for something, and people logically sometimes thinking they can convert it to a use that, you know, it seems to be straightforward. Not so straightforward. You now trigger the Building Code of Canada, and you trigger a whole new set of rules. So what does this act require for building construction? Those rules have not changed too much. You have to obtain a building permit, and you now have to provide planning services with notice that you're going to start. You have to now tell them who your contractor is, who your architect is, items like that. That is new for this community. You got a building permit, and basically you did not have to advise. You do going forward. During construction, you have to follow, as I said, the National Building Code 2015 and the plans that were approved. You also have to maintain copies of your plans on site, and you have to advise the commission, I guess it's planning services, of any change in those contractors or engineers. And you have to obtain the inspections that the law requires, such as for your foundation, etc. So the rules have not fundamentally changed on what you need. What has changed is the enforcement of the act. And here's basically, well, in a nutshell, it is penalty driven and not I guess, compliance driven. So if a violation is observed under this act, the building inspector can issue an order to comply. That order is served by the bylaw compliance officers the city has employed, and once you receive that, all work has to cease, except work necessary to comply with the order. If you don't stop the work and start to fix the problem, a charge will be laid in provincial court. The bylaw officer will have to attend provincial court, swear the charges, and I'll get into a little later, but the orders that are being served now have, I guess, more dire consequences than what we had before, insofar as you now have financial penalties. So the charge is sworn, a summons is served, and if a person says or pleads guilty or is found guilty, the court can impose a fine of up to $5,200. There are a number over the years of people who have received these orders to comply who have not complied in time, and under the new law, they will be charged. They will attend Monday morning court. with people that are charged under the criminal code, drug offenses, fish and wildlife offenses. It is not an administrative body. It is guilty or not guilty. If they don't follow the court order, they face a separate charge and a fine of up to $20,500. And the last one is probably the most important for the first time since I can recall. People in Miramichi who do not follow our building bylaw could end up facing time in jail. And we cannot change that. That is a provincial act. We do not control that. So I just want to summarize for you how this changes from what we do. So if we get a call today that somebody has built a second story on their home and they don't have a building permit, files that involve risk to life or limb or public safety are given priority. What we have done is hired legal counsel, and we have taken these people to the Court of Queen's Bench. We have not sought a penalty. We have sought only compliance and an order that that person comply and fix the problem. We can't do that anymore. So that's off the table for us, working with people to get compliance. We are not allowed to issue a ticket, meaning you get a piece of paper at the work scene, you pay the fine, and who has to go to court? Nobody. That option is not available. Orders are going to be served by the bylaw compliance officers, and the severity or the potential consequences explained. Previously, you got a letter in the mail telling you, please comply with this, and it came from planning services. The city, more particularly my office, oversaw the picking of files to take to Court of Queen's Bench, and it was based on safety issues. Now that there's only penalties available, the city cannot control what files the city takes to the court to get enforcement. These are akin now to criminal matters. Therefore, we have retained an independent legal counsel who will clear all the charges and approve them. That is different. It is no longer appropriate for my office or anybody in City Hall to direct who gets charged and who doesn't get charged. We weren't charging people before. We will be now because we have no charge. We have no choice, I'm sorry. Charges are going to be sworn and summonses served by bylaw compliance officers. The Provincial Court in New Brunswick will have jurisdiction after the plea is entered, not the Court of Queen's Bench, and the imposition of jail time is a possibility. So as you can see, my message to people is things have changed on the landscape of not building in accordance with the Canada Building Code in Miramichi. We do not have, and I'll stress that, we do not have the authority anymore to take you to a court and work with you, and at the end of the day, just discontinue when you complied. There are penalties. There are minimum penalties. And as you saw, if you decline to follow an order, you could face a financial penalty up to $5,200 for not doing what the planning authorities tell you. That is the message. That is what, I was trying to, I wish that, the public understand, and that, if they make themselves familiar with the legislation, they contact the planning authorities to find out how it applies to them. We will try and educate through our bylaw compliance officers, so when they do deliver things, they will make known to the individual, this is serious stuff, this is what could happen, please, please call a number here and deal with these people. That's how we're going to try and soften it, but it's fundamentally a question for or it's a change in how we do things. So that's the essence of the presentation, unless council has any questions on the file.
Very good, Manager Mike. I suspect there'll be a few questions from the floor here this evening. I just, from the chair, if I may, actually, Councillor Harris, you go ahead. Sorry.
Oh, go ahead.
Councillor King?
Okay. Sure. Okay. Thank you, Deputy Mayor. Thanks, Mike, for the presentation. We got it last week at our bylaw committee meeting, and it is it's a big change, not just for the city and Mike's office of how we used to deal with contractors or with redoing renovations or anything like that. Mike, just a few questions. This law, this is not City of Miramichi. This is the whole province of New Brunswick, the City of Moncton, the City of Bathurst, City of St. John, the Village of Woodstock. Everyone's going to be under this umbrella.
Yeah, one end applies to the whole province.
So the province put this in about 6 months ago, went into law, I think you said the other day.
It was originally, I think, proclaimed in March of 2020, and they tinkered with it and changed things. Like a lot of legislation, when they put it on the books, they realized it wasn't perfect. It didn't get into our world, well, sorry, the final consolidation by the province was December of 2021. It didn't come into our world till we started to do an enforcement. And we don't do, as I say, take people to court regularly. That was about a month ago that we realized it was now part of the Miramichi, city Miramichi landscape. But it's been on the books for a little over a year.
So when these issues come up and we do have an issue, we have a problem within our city, I presume the Regional Service Commission will handle it first. They'll contact the city to say this address, this is what's going on, and they're going to ask the city to send out our bylaw officers to enforce this law for them.
No, what will happen is if they identify that there is an issue and they don't have all the evidence, then either the bylaw officer or the inspector or building inspector will attend the property. What will happen is the call on whether there appears to be an offense will be made by the planning authorities, not by our bylaw compliance officers. So the person who has to know whether there appears to be an offense is the bylaw compliance. They would issue an order to the individual. If the order is not followed, a lawyer is going to make sure the file is looked at before anybody is charged with anything. So the first level of we think you are violating is decided by the planning commission people or the planning staff. And so our bylaw compliance will not be the people who know inside and out this act or those building bylaws. They will encourage people to contact the numbers that are in the orders to find out what they need to. So, the process will be initiated by planning staff. Charges won't be laid until a lawyer is signed off.
Yeah, so the city of Miramichi, really, we have nothing in this really. At the end of the day, it's a service commission that's going to be making the call if there's an issue, to send out the bylaw officers to have a look, and then there's an issue to report back, and hopefully there's some communication back and forth. The old Miramichi way, I guess, to try to talk things by calling a number and make sure these people know to call this number. It's very important, and try to work through it before we have to deal with it this council, because obviously everything goes back to council. This will not, I understand, but we will still get it back at council, that, from our private phones or whatever like that. That's what I'm trying to say. So
we have had meetings with bylaw compliance and planning and legal counsel, and the message that's been delivered is that the city of Miramichi wants compliance, not fines. Okay, the city of Miramichi does not want to lose charges because we waited too long. There are time limits on some of these, like 6 months. But the first week shouldn't be laying charges. The first number of months should be spent trying to get compliance. Bring the attention of the apparent violation to the individual, encourage them to try and fix it. And to be frank, unless the person looks at the bylaw guide and says, screw it, we will give time for people to try and get it right before we ever charge. Okay, I have conversed with legal counsel and made it clear that that is the policy that the city would like as far as enforcement, and there has to be a common sense or community benefit. To equate it, council would not want their police department to issue regular tickets of people going 53 and a 50, and we don't want that attitude when it comes to prosecuting people on these type of offenses. It's life and limb get the priority. Okay, so issues, if you're plugged 6 inches too high, I wouldn't expect somebody to get charged. If they built a second story onto a building without a building permit, we are going to enforce that. Somebody's going to buy that house someday that doesn't know that there was no permit. So we are going to try, those are the guidelines we are giving to everybody that's involved in the working through of these, and we trust that they will follow those guidelines.
Thank you, Councillor Harris. Councillor King?
Harris more or less got my question. The thing is, Mike, if somebody wants a building permit, they're going to be told up front what's happening, right?
Yeah, well, what'll happen is, we're not that far away, anybody in this room for the days of literally napkins, we're going to the planning commission.
Yeah.
And those days we are moving away from those. And we are, people need to get plans done. You're building a house. You're building, something that's going to last for decades. So the days of, I built 3 for my kids, I'm going to build this one, I don't have plans, are probably long gone.
Yeah.
But that doesn't mean you don't work with people to make sure that they get their building permits and know what's going on. As I say, it is complicated. Interestingly enough, there's a section in this act that specifically says that while the planning staff should answer straightforward questions, it is not the role of planning staff to be a designer or a contractor. And I was somewhat surprised to see that in the legislation, and I think it reflects that attitude of people go, the planning people won't tell me what I have to do. Well, they put it right in the act. The planning people, it's not their job to tell you how, to step into an architect's world or an engineer's world. So, there has to be some get your advice counselor from, somebody besides the planning staff. And we're going to work through that. I mean, the community is not, we're not there yet as a community where you expect you're getting a house, you're going to need all this stuff. You still think you can do this pretty informally. And so we're going to try and work with people too.
What's the main reason they upped the fines, Mike? And the fines are pretty stiff there. Any idea?
I'm not sure what motivated it. I mean, the rules did always apply across the province. I don't know if they were enforced consistently across the province. As I say, this didn't get into our circle. We always had the option of taking people to court. The city of Miramichi chose not to penalize people, and we took another option. So it's consistency. We believe it has something to do with clearly public safety. Okay, people are building structures that people are going into, and nobody really cares. We're all supposed to make it easy to do until the building collapses, and it's who's to blame. And so that's where I think, a little bit of this is. So.
All right, thank you. Thank you, Councillor King. Councillor DePlacy.
Thank you, Deputy Mayor. You alluded to my question on kind of the subjectivity of it, and I know when I was trying to familiarize myself with the issue of building in the city, the subjectivity of the building code would always come up. And especially developers or small-scale, mid-scale developers would say, well, you can go to Bucktouche, you can go to Dieppe, and they don't enforce that. So I'm hoping that there's some consistency around the province when it comes to this now, that markets aren't using the building code and the subjectivity of the building code to be more competitive for building buildings, because I suspect it was happening in other regions. And I'd give our planning commission the benefit of the doubt, because I know often they took the harder line on building code things to the point where appeals had gone all the way up to be changed through that process, which leads me to the next question of when does that happen in this process, that someone would trigger or apply for an appeal to the building code? Would it be in front of the courts, or would that be
an appeal to the building code?
Mm-hmm.
I don't know if there's any such thing.
Well,
the building code is drafted by the National Research Council.
Right.
And either what we were looking for before this legislation came out was a third-party mechanism where you had two sides seeing with opposite views on how to interpret it, that we'd have a quick mechanism to go to somebody, get a darn ruling within a couple of days, and everybody moves on.
Yeah.
They did not build that into this legislation.
Right.
So the problem that you're talking about, I don't know if this act's going to solve it.
Okay.
And there still might be the difference in interpretation from our planning staff versus another community's planning staff. What I can tell you is we've talked, the legal counsel that is going to do most of this for us, and we agree that what this will do is it'll provide case law with interpretations of different sections that everybody will eventually have to live with. Unfortunately, that takes years.
Yeah.
For a case law to develop so you can look at a case and say, okay, that's what that section means. But, so I can't promise you or even suggest that the problems you're alluding to will be made better by this act.
Yeah. No, I understand.
I think they're more addressed by the constant messaging to the commission of what the desire of council is, as I interpret it, in terms of enforcement and helping people and getting this done. It's about compliance. It's not about fining people. It's not about charging people.
Right.
And so that, I think, is the message, if we keep giving, that may address the problem you're talking about more than any legislation.
Yeah. Okay. Well, clear as mud. Thank you.
Thank you, Councillor DePlacy. Councillor Johnston?
Thank you, Deputy Mayor. I'd just like to reiterate, Mr. Manager, that although this policy can seem foreboding with the change in perspective, the first stage of this process involves an educational piece and corrective problem solving to help avoid any contentious litigation or anybody being fined or punished. And again, the first piece is corrective problem solving, the education, so that folks have safe structures and that public safety is the order of the day.
That's correct.
Thank you, Councillor Johnston. And I think it's worth circling back to something Councillor Harris alluded to, just to in the interest of clarity here. This is a law and legislation in the province, and this is not, Mike, and you can confirm just one more time for folks, this is not a Miramichi thing, this is a New Brunswick thing, and
No,
it
this
is a
is
matter
some-
of playing the hand we're dealt, as it were.
This is not, we have to use this. We have no option anymore to enforcement of building other than this act and the consequences that it has in it. You're correct.
Okay, very good. Anyone else? And with that, we'll carry on. Thank you, Manager Mike, for your